All right, welcome everybody. Thank you so much for attending the second workshop that we have here at the LAIF 2020. It's wonderful. We have the first, and everything is going to be recorded in the video vault if you want to see it again. This is the second workshop. We have with us Matthew Whitfield, he's a manager lawyer for the legal services of Northern Virginia. And he's going to be presenting the class, Eviction Prevention and Your Right as a Tenant. So please, with this, Matthew, take it away and give us all that good information.
Great. So let me pull up the PowerPoint. All right. Hello, everybody. My name is Matthew Whitfield. I'm an attorney with Legal Services of Northern Virginia. I'm doing this session on eviction prevention and knowing your rights as a tenant. I'm going to briefly talk about LSNV, how we can help, how you can apply for our services. I'm going to go into the eviction process in Virginia, and then I'll discuss some recent updates concerning COVID-19 and new Virginia housing laws that were recently passed. Legal Services of Northern Virginia is a nonprofit law firm. We aim to provide legal services and representation for those who are low income or elderly. And so our services are free. You don't have to pay for our services. I also want to briefly mention that we're celebrating our 40 years of celebrations. So if you have the opportunity to attend on November 12th, you should join us that night. And I also want to mention that we have locations throughout Northern Virginia. We also have an office in Arlington. And you can find this page on our website as well. How we work. So we need to screen people before we can give any specific legal advice. And during non-COVID times, we're able to do walk-ins, but right now we can only do this by phone or online. So you can give us a call at the number listed on the screen Monday through Thursday at 9:30 through 12:30 or 1:30 through 3, or you can go online and fill out an application that way as well. And some of the practice areas that we can help in. We don't do criminal law, but we do a lot of civil law. And so we do family law, elder law, such as if you need an advance directive, power of attorney, or will, housing law, consumer law. So if you're being sued for money, if there's a garnishment, or you're looking to discuss a bankruptcy, that's something we can help with. Public benefits, if you need help with Social Security, or you have issues with Medicaid, that's something that we can assist with. We have a couple clinics that can help people, and victims of crime is something people we can also assist. Specifically with housing law, we can help with evictions. We help with maintenance issues, or if someone has issues with their subsidized housing. We also assist with unlawful lockouts or security deposits, or if there's been some sort of illegal utility shut off. That's something we can assist with as well. And I think it's important to bring up that a lot of people assume they're always going to have access to an attorney in court. But that is only true in a criminal case. So if there's an eviction, if there's a garnishment, bankruptcy, a protective order, unfortunately, you are not guaranteed an attorney. And so this is where legal services can come in and try and help people, because the court system is not friendly for someone who is not an attorney. And you can see this in the justice gap statistics. Only 2% of defendants in civil cases have an attorney. And then when the plaintiff has an attorney and the defendant doesn't, the plaintiff's going to win 60% of the time. If the defendant does get an attorney, if legal aid is there to help, then that goes from 60 to 20%. And that's a big difference. And it just shows that having an attorney, having access to justice has a meaningful difference. And then I like to use this Brian Stevenson quote when I can, that the opposite of poverty is not wealth. In too many places, the opposite of poverty is justice. And I think here, the opposite of poverty is legal aid and help in the court system. So I'm going to briefly again go through the eviction process so people know what they can expect as a tenant, and then we can go into some defenses that they can use to try and prevent such an eviction. The first process I'm going to discuss is if non-payment of rent, if the payment of rent is an issue and the reason for an eviction. So typically the lease, and most people will have a lease, will say that rent is due on the first of each month. Now, legally, it doesn't have to be due on the first of each month. Some leases will say 15th, but most are going to say the first. And then most are also provide a 5-day grace period where if you pay between the first and the fifth, you won't have to pay that late fee. So this is a typical timeline that I'm going to go through. Now, if the tenant is unable to pay on the first and they're unable to meet that grace period date as well, then the landlord may provide a written 5-day pay or vacate notice. And again, that must be written down. It can't be verbal. And it's a notice that says that you have 5 days to pay what you owe, or the tenancy is going to be terminated and they can file in court. So as long as you pay within that 5 days, then you should still be fine. Now, around day 12 or 13, if the tenant has still been unable to pay what they owe, then the landlord may file something called an unlawful detainer. And that's just a scary legal term for saying they can file an eviction lawsuit. And then you will be served with a summons at your door, letting you know of your court date, which is called a first return date. And that's going to be roughly around day 33 or 34. And again, if the tenant pays everything, that would include rent, late fees, attorney fees. If they pay everything by the first return date, then they will get that case dismissed. That's called redemption. Though you can only redeem once in a 12-month period. So you can't keep going to your first return dates and paying everything. You can only use that redemption one time. And then, so again, around day 33 to 34, you're going to have that first return date. That's when you go to court the first time. In Arlington, that's typically going to be at 2 o'clock at the courthouse, and most of them are going to be on Thursdays. It doesn't have to be. And then every tenant should show up so they can argue their case. I think it's also important that this is a scary process for many people, and unlawful detainer sounds pretty scary as well. And a lot of people think there might be some jail involved or it might be criminal, and that's just not true. In Virginia, jail is just not something you have to worry about. You're not going to be arrested for not paying your rent here. And so that's just something to keep in mind. And then at the first return date, if you tell the judge that you dispute what you owe or you dispute the reason why for the eviction, the judge is going to set a trial date. In Arlington, this happens without trouble most of the time. And so then around day 38 to 44, you're going to have that trial where you should be prepared to come to court with evidence showing why you think you should not be evicted. And then if the landlord happens to win that trial date, there's going to be a 10-day appeal period where you can appeal to circuit court if you have lost. Now, if it's a non-payment of rent case, you will have to pay an appeal bond before you can appeal that decision. And then the landlord is going to get something called a writ of eviction. That's what they get when they win at trial. The sheriff will get that writ, and then they're the ones that are going to execute. What's going to happen is after that 10-day appeal period, at some point the sheriff's going to come and give you 72 hours notice. Now that's the minimum they have to provide a tenant. Sometimes it's going to be more than that. You're going to see between 5 and 10 days, but the minimum they have to provide is 72 hours. So you're going to get a notice on your door with a date at least 72 hours out saying the sheriff's going to come, and that's when they're going to come and change the locks on the door. And again, this is just a typical timeline. Some parts of it are going to vary depending on the court and what your lease says. Then the other reason for an eviction could be a breach of the lease. So this is a slightly different way to evict than non-payment. The landlord still has to provide a notice, but it's going to be either a 21 30-day notice if the breach of the lease can be remedied or fixed, or it's going to be a straight 30-day notice if the problem cannot be fixed by the tenant. Typically, that's going to be something criminal or drug related. What the 21 30-day notice means is that the tenant has the ability, the right to fix whatever the issue is within 21 days. But if they don't, if it's reoccurring, then that tenancy is going to terminate at 30 days. And so typically one popular example is noise violation. So the landlord is going to provide a 21 30-day notice saying you have 21 days to correct this noise violation. And if the tenant stops after 21 days or within that 21 days, they will not move forward with that eviction. And then again, the landlord, after if they do have that violation still, they can file a summons for unlawful detainer. Again, that's just a scary way of saying an eviction lawsuit. And then the rest of the trial process sort of works the same way. You're still going to have a first return date. The tenant can still show up and dispute the reasons for the eviction, ask for a trial, can also ask for pleadings. And then there will be a trial date set up as well. And the tenant and landlord will be able to discuss with the judge their availability for that. And again, the writ of eviction works the same way as in a non-payment case. There's still a 10-day appeal period, and the sheriff still has to provide that 72-hour notice. Now, it's important to mention that there is no self-help eviction in Virginia. So what that means is the landlord can't just evict themselves. They can't just change the locks. They can't just cut the heat off in the middle of winter and try and freeze a tenant out. They always have to go through the court system. They always have to take a tenant to court before they can evict. So they can't just do it themselves. A tenant should always have the right to have their day in court. I also want to talk about redemption again. So we discussed that if a tenant shows up to their first return date, their first court appearance, and pay everything, then they will not be evicted. The case will be dismissed. As of July of last year, a tenant has the right for an extended redemption, which means that even if the tenant loses at trial or their first return date, they still have the opportunity to redeem. They have this right at least 48 hours before the sheriff comes after they provide that 72-hour notice. So you still have the opportunity to redeem even after a tenant may have lost their lawsuit in court. And then again, if you have questions about that, you can call legal aid. And we'll be able to assist with that. Again, to redeem at that point, it's a good idea to pay by cashier's check or certified check. And once you have, it's important to just let everyone know. You should let the sheriff know you redeemed. You should let the landlord know. You should let the landlord's attorney know. So everyone's on the same page. And again, you can only redeem once per 12 months. And then you have the right to appeal, but if it's a non-payment case, you're still going to have to pay that appeal bond, which is the rent that you owe. So that's a barrier to a lot of tenants to appealing to the circuit court. And again, this is a scary process, and you don't have to go through this alone. So give LSNV a call to discuss with our intake. Our number is 703-778-6800. You can also go to Arlington County to see if you can get any rental assistance, and I have their number listed here as well. That is 703-228-1300. And then now I want to discuss some COVID-19 updates and recent housing laws that were passed in 2020. I'm just going to bring up some from 2019 because they're still pretty new as well. So the federal government passed the CARES Act back in March. And in that CARES Act was an eviction moratorium that prevented some properties from evicting tenants. Now, these covered properties were Section 8 properties, other subsidized properties, or landlords that had certain federally backed mortgages. It's very hard for a tenant to know if the property they rent is covered. There are search engines online that a tenant can use. We have them on our website at lsnv.org to help tenants find out if their property is covered. So the moratorium part of this was lifted back in July, but there are still protections under this act that a tenant can take advantage of. And one of those is that a non-payment payment issue, if the landlord's trying to evict for non-payment of rent, rather than providing the state law 5-day pay or quit notice, these covered properties still must provide a 30-day notice. There is no sunset provision there. So even though the eviction moratorium has been lifted, these landlords still must provide a 30-day notice for non-payment of rent cases. So it gives the tenants 25 more days, which can make a big difference in seeking rental assistance or getting to their next paycheck in order to pay what they owe. So that's something tenants should be aware of. They should make sure, they should check if the property they rent is federally backed, or if the landlord has a federally backed mortgage. And again, we have search engines links to those online. You can just put in your address and then see if your property, the property that you live at, is in these databases. And this is something that you can call us at Legal Services as well, and we're happy to help tenants with that. One other big COVID-related tenants defense is the CDC, or the Center for Disease Control and Prevention, that many may have heard about. This is a federal moratorium on evictions if it's for non-payment of rent. And in order to qualify, the tenant must earn less than $99,000 a year, or if it's a couple, $198,000. If they have a substantial loss of income or have any high medical expenses, and if they would be homeless or would have to move in with others if evicted, then they would likely be able to take advantage of the CDC order and declaration. So what it does is it stops evictions. Each courthouse is going to handle it differently, but in Arlington, if you show up to court with a signed copy of the declaration, you're likely to have the judge continue your case out to January 7th or past that. So it's something that is not an automatic defense. The tenant is going to have to be proactive with this. You're going to have to find a copy of the CDC declaration. You're going to have to review it. You should provide a copy to your landlord, the landlord's attorney, and if you have a court date, you should make sure to bring a copy of that with you to court. And it doesn't just stop the eviction in court. Even if you've already lost at court, you didn't take advantage of the CDC order, so you didn't know about it until it was too late. even though you may have lost at court, you can still prevent the sheriff from executing the writ of eviction. So you can still sign the CDC declaration. You can still give it to your landlord. You should then give it to the sheriff's office and prevent the execution of the writ, which is the sheriff coming to change the locks. And we have copies of the CDC declaration on our website. We can find it in multiple languages as well. So if you have questions about the CDC declaration, you can call us or go on our website and take a look at that. You also have to be looking for rental assistance. That's just another requirement that you'll see when you look at the declaration. So you can contact Arlington County, DHS, and see if you qualify for any rental assistance. And once you've done that, then you've met the requirement to sufficiently sign this CDC declaration. It's also important that each adult signs their own declaration. So if there are multiple adults under the lease, they should each sign their own document and each provide that to the landlord and the judge. You don't want just one adult for the household signing it, because that's just not going to work for everybody. Another important update that was COVID related that tenants should be aware of is the 60-day continuance. So starting April 22nd, if a tenant has experienced loss of income due to COVID, they can ask the court to delay their court date by 60 days. And this can be any loss of income. It doesn't have to be an entire loss of income. And then I think even if you're unemployed at this time, with the employment rate so high due to COVID, that's not the tenant's fault. They should be able to use that as a reason as well. So there is, it's a little harder to use in the CDC order. You have to bring proof with you of a loss of income. You can do that by bringing a pay stub with you, any written documents that you may have. But if you have a hard time getting this evidence of loss of income, if you can't find anything that would work for that, you can also sign an affidavit, a document stating that you have lost income due to COVID-19. And because of that, you wish to have this 60-day continuance. And so we have draft copies of this affidavit on our website. So you can go on lsnv.org and find a copy of this draft. I believe it's also in our exhibit hall. Or you could give us a call at LSNV and we'll be happy to walk a tenant through this process as well. And this is still ongoing. A lot of tenants might have forgotten about this 60-day continuance because of the CDC declaration. But the CDC declaration is going to run out at the end of the year. Pretty soon, this month, this 60-day continuance is going to buy more time than that CDC declaration is giving. Because the CDC declaration gets you until the 2021. Pretty soon, the 60 days is going to put you past that. So it might be a good idea if you have a first return date to bring with you both a copy of the CDC order and a copy of the 60-day continuance to request that from the judge. And I have a copy of our model affidavit right here. Again, it just states that you have lost income due to COVID-19 and that you couldn't find any written proof, so you're going to sign this affidavit. But if you do have proof, it's better to bring that with you to court. So an update from the last General Assembly session that is very important is that landlords can't charge more than 10% late fee or 10% of the balance due, whichever is less. And so this is an important new law because landlords were charging large amounts in late fees. And then while the tenant could pay the rent they owe, they were getting stuck with these large late fees. So now the landlord is capped at 10%. If the landlord files for an eviction and asks for more than 10%, then we can get that eviction case kicked because they're asking for an amount that is illegal. You can only ask for up to 10%. Even if a lease was entered into before this law went into effect, and even if that lease allowed for a higher percentage, the landlord still can't ask for more than 10%, no matter when that lease was signed, no matter what that lease says. The landlord cannot charge more than 10% of the rent that is owed. And also, if a tenant has a Section 8 voucher or some other subsidy that they're using to pay for their rent, what we've seen before is if that subsidy was paid, the landlord would use a percentage of the whole rent, the entire rent, even the subsidy amount. So the tenant would be stuck paying an interest for the entire rent, even though they don't pay for some of it. So what this new law also does is it states that the tenant only owes 10% of the balance due. So if they only pay 50% of their rents because the subsidy pays 50%, the landlord can only do 10% of that 50%. So that might get a little complicated if a tenant has questions about late fees, if they think the landlord's charging too much. That's something that you can contact us as well. And again, the landlord can only charge a late fee if the lease provides for it. So that's something else to keep in mind too. If your lease doesn't say the landlord can charge a late fee, they shouldn't be asking for it then. And then another new law that was passed in 2019 is if there is no written lease, if it was some oral agreement, if it was verbal, the law is going to put in place a lease for you, and it's going to be a 12-month lease, and that lease is going to allow landlords to charge a reasonable late fee. So even if you don't have a lease written down, the law basically puts one in place for you, and that one is going to allow late fees. But again, landlords now always going to be limited to 10%, no matter what the lease says, and no matter when that lease was entered into. And if the landlord is trying to evict based on not paying these high late fees, we can get that eviction case kicked out of court. Another new law that was passed recently that starts July of this year is the ban on source of funds. So previously, if you were getting some sort of subsidy, the landlords might not allow a tenant to rent because of that subsidy. And so this new law prevents that from happening. You can't deny a tenant from renting because they might be trying to use a subsidy. It would be a violation of the Virginia Fair Housing Law. So if you think that's an issue that you're running up against, if you think a landlord's not accepting you as a tenant because you have a voucher, then you can give us a call, and that is something that we can assist with. There are a few exceptions to the source of funds protection. The landlord, if they own 4 or fewer properties, then it's not going to apply to them. And then there's an issue if the source of funds is not improved within 15 days, then it doesn't come into play either. But that doesn't happen too often. And then if there's been an unlawful exclusion, if a tenant has been unlawfully locked out of their residence, then you can get an ex parte hearing, which is an emergency hearing. So you can get before a judge pretty quickly in order to make sure you get back in. And because the landlord always has to go through the court process before there can be an eviction, there is no self-help allowed in Virginia. Another new law that was recently passed was that when a tenant signs a new lease with a landlord, the landlord must provide a information sheet basically of the tenant's rights and various resources the tenant can access to discuss those rights as well. So starting July, every tenant, when they sign a lease, they should be getting this information sheet um, from their landlord, and the landlord's not going to be able to file any eviction lawsuit until they have proved that they've provided such a information sheet to the tenant. Arguably, even if a lease was already entered to, the landlord should still be providing this information sheet before they file an eviction, but they should definitely be providing this to tenants when a tenant signs a new lease. And this a model information sheet is available on the Department of Housing and Community Development website. And then there's also going to be a notice to subsidized tenants about legal aid. When there's an eviction notice, the tenant that has access to the subsidy is going to be given notice that they can contact legal aid for assistance. And hopefully this is already happening in Arlington. I believe every UD that goes through, every unlawful detainer or eviction lawsuit that goes through the courthouse is getting a copy of information pointing tenants to both Arlington County Rental Assistance and Legal Services of Northern Virginia. So hopefully tenants are getting the information they need to get these resources. And then another big change in the law that starts July of this year, repair and deduct. So what used to happen is if tenants if they kept telling their landlord to fix something broken in their tenancy and their residence, and the landlord wouldn't fix it, the tenant would either not pay rent and then get evicted, or they would try and fix it themselves, and they weren't legally able to do that. But now if the tenant provides notice to the landlord that something is broke, if they provide 14 days for the landlord to fix it, and the landlord still doesn't, then the tenant can pay for these repairs themselves. If the contractor is licensed, and we have ways to figure that out at legal aid, so you can contact us. But then once the tenant has paid for the contractor to fix the problem themselves, the tenant can then deduct from their rent up to $1,500 or 1 month's rent, whichever is higher. So this will allow the tenant to fix something themselves. They don't have to wait for the landlord to do it or go through the court to force the landlord to do it. They can provide the 14-day necessary notice, then fix it themselves with a contractor who's licensed, and then deduct that amount from the rent that they owe. Now, I still recommend that even if you want to go this route and you don't want to do a tenant's assertion, which is more complex, you should still contact legal aid. It's something we would like to help with, and we just want to make sure that tenants don't do something wrong if they don't wait the appropriate time or they try and deduct too much from their rent. But this is something that tenants can do going forward, and it's a big change. And then discussed this briefly previously, but again, if there is no written lease between the tenant and the landlord, the law is now going to put in place a lease for you. And this lease is going to be 12 months. Yeah, the rent's going to be on the 1st, and there's a 5-day grace period. A reasonable late fee may be charged, though again, it's capped at 10%. And so if you have questions about that, that's something we have more information on our website as well. And then other defenses a tenant may use if they're looking at an eviction. one is just to make sure they've received proper notice. So if the tenant is asking for rent, make sure they're asking for the appropriate amount. If they're asking for too much, then it's not what is called the proper sum. And so then you can get that eviction case dismissed in court. So it's important to make sure that you review the notices, make sure they're asking for the correct amount. If they're asking again for late fees that's greater than 10%, that is not the proper sum and that will get dismissed. Make sure that you are served properly. So you have to have notice of anything that happens in court. So if there's an eviction case, you have to be served properly and given the sufficient time to do that. And then also make sure that the landlord's also following the lease. So the lease is basically a contract between the tenant and the landlord. And so you just want to review the lease, make sure that the landlord's following as well. And if they're claiming that there was a breach, you can review the lease and look to see where that breach was. And then also if the landlord's breaching the lease, if they're not following their obligations, the tenant can also file for assertion in court, which means that if you give written notice to your landlord to fix their violation of the lease, then you can file a tenant's assertion. There's a form at the clerk's office. You file it in court, you schedule a court date, and then the tenant can start paying their rent to the court rather than to the landlord. And that also provides an incentive to the landlord to fix whatever the issue is. And then I think it's important to let tenants know there are additional eviction protections in Virginia that will be taking place soon. They were passed in the recent budgets by the legislature. The governor hasn't signed it yet, and the governor might make changes. I don't know. But when that happens, we will be putting information about these new protections on our website. And then if there are additional questions, you can reach out to me or give LSNV a call as well. So this will be taking place soon, hopefully. And then I've saved some time for questions if there are any.
Yes, if anyone has any questions, you can go ahead and unmute yourself. Just remember to mute yourself after asking your question, or you can submit your questions through the chat function in the chat box. Thank you.
Hello, this is Jorge. Just want to remind everyone that all the presentations are going to be recorded later on in the video vault. And also Matthew has an exhibit page here in the exhibit hall, and all the information is posted there too. There is not a phone number. Mario, why don't you have a phone number there?
It should be there. It could be on the side, or you can go to our website and find out that way as well. It's also on this presentation right here. So again, that's 703-778-6800.
Yeah, I'm sorry, I misspoke. That it was a saying that you want to be called on today live because there is an issue with every case is different or things like that, isn't it?
Yes, so we can only provide general information without doing a screening. If someone wants specific legal advice to their own particular set of facts, their own circumstance, we're legally required for them to go through a screening process. So this is the way to do it. You can either go online or call us Monday through Thursday.
Go ahead, Saul.
Yes, Renee has posted the website link to the Legal Services of Northern Virginia exhibit hall, where you can find that same information on the phone number to call and links. Now, someone here asked a question in the chat box, Matthew. I don't know if you're able to see that, but I'll read it to you. The
Great,
question
thank you.
says, where can I get the list that I would get from the landlord when signing a lease?
Where can you get the, I'm sorry, the what? Is this the information sheet?
Yeah, this is Leslie. Can you elaborate a little in the chat box about what list it is you're referring to? The question, Matthew, says, where can I get the list that I would get from the landlord when signing a lease? And she said, yes, the information list.
Yes, so the landlord should be providing that to the tenant. Now, if the landlord wants to know where they can get a copy of what they're supposed to give to the tenant, it's available on the Department of Housing and Community Development website. Or if the tenant's just interested to know what they should be getting, it'll be on that website as well. It provides basic tenants' rights and the number to call the local legal aid. But the landlord should be providing this to the tenant when the lease is signed.
Saul, any more
So
questions?
we have about 3 more minutes left. If anyone has any other questions, if you'd just like to talk, you can unmute yourself or type your question in the chat box. Well, I think your information you provided was very clear.
I have a question for you, Matthew. Will that 60-day continuance, will that prevail over the eviction on cases with housing vouchers?
Yeah, so if the tenant still, if it's a non-payment of rent case, they should still be able to use that 60-day continuance. One difference between the CDC order and the 60 days is with the 60 days, you have to link the loss of income to COVID-19. So that's just something a tenant will have to prove to a judge. Though I would argue even if a tenant is just unemployed right now and has been the entire time, with COVID caused a high unemployment rate, that's not the tenant's fault. So they should bring that up to the judge.
Thank you. One more question, since no more question there. On the rent and repair, the new law,
Yeah.
how do you see that going in the future when there is cases of either mold or bed bugs involved?
Yeah, so again, I would recommend that before a tenant goes this route, they should just contact us because we would work with the landlord first to see if it can be fixed. And then arguably, uh, if the reason for either the bed bugs or the mold is not the tenant's fault, then they should be able to use this, though you might run into that cap limit of the 1,500. So the tenant's assertion might be the way to go for that as well, where you file in court and then have a judge decide. And that's something that legal services can help with as well. It's also important to make sure that you get a licensed contractor, so you can't just hire your friend who might do it on the side but not licensed. So it's important that you get the right person to do it as well.
Matt, we have a question in the chat box. It's in Spanish, so I'm going to try to translate. If anyone can help me with the translation, I would appreciate it. Also, correct me if I don't translate it correctly. But the question says, when will this information apply, as far as when would the landlords start charging us late fees for paying rent late?
Okay. Well, first, I do want to mention that legal services, we can help people with any language. We have a volunteer network and interpreters. So if anyone speaks any other language other than English, we're of course still able to provide assistance. Now, the question of the landlord,
Charge late fees.
so they can, it depends on what the lease says, really. If the lease allows that 5-day grace period, then what you're going to see is that after the 5th of the month, if the tenant still hasn't paid, then the landlord is going to apply that late fee charge, but they're still going to be capped at either 10% of the rent that is owed. So there's a cap on it, but when they can start charging it really depends on what the lease says. Typically, it's going to be after that 5-day grace period.
Okay, I'm putting the answer in the chat box for the person translated. So that question was asked by Giovanna. And so Giovanna, I can say in Spanish, dice él que esto depende del contrato. Si el contrato permite 5 días para pagar, entonces después del 5.º día, el dueño le puede cobrar la multa por pagar tarde. Pero dice que el límite, hay un límite en eso que es el 10% del monto de la renta. Thank you, Matthew.
Thank you.
So we're at 11:47. That is it for questions. We'll be ending this call in about 3 minutes, so we're just going to finalize and allow Renee to end the workshop. And thank you so much, Matthew. Jorge, is there anything else you'd like to say?
Yes, I want to thank you, Matthew. I want to thank everybody. And please, we have 3 more wonderful workshops. If you want to go for a break, that's fine. But we have 3 more wonderful workshops. And thank you, Matthew. Thank you, Legal Services. Thank you, Bugara. And see you next.
Thank you.
Thank you, everyone.